USCIS denied over 60,000 family-based green card applications last year, and a big chunk of these denials came down to red flags that most couples did not even know that they had in their case in the first place. Some of these red flags are obvious, but others will shock you because they are things that even real legitimate couples do all the time without realizing how bad it looks to USCIS. So in this video, I am going to walk you through the red flags that USCIS considers in marriage green card cases in 2026 in order to get your case denied. So to start, I'm going to show you some of the more surprising red flags, ones that most people don't even understand are harmful. This one surprises a lot of people. If you show up to your green card interview and you're holding hands the entire time, you're kissing, you're touching each other, and in general, you're being too lovey-dovey, this is a red flag. The officer is not going to think that this is sweet. Instead, they are going to think that it's fraud. They are going to think that you are putting on a performance. And this is because most average couples do not behave this way in a government proceeding. So no matter how much you love your spouse, save the public displays of affection for outside the USCIS office. USCIS officers are trained to see how you behave during the interview. If you come across as nervous, for example, if you're fidgeting, if you're sweating, you can't make eye contact, they can treat these as signs of potential fraud brewing underneath. And the same goes for if your answers sound like they're memorized or rehearsed. They expect people and couples to answer questions naturally, even if the answers are not perfect. And even if you stumble a bit, that is much more believable than a perfectly scripted response. If you met your spouse through a dating app or online, USCIS may also treat this as a warning flag. The concern is that some people use websites specifically to find US citizens to marry in order to get a green card. On top of that, if your entire relationship was long distance for long periods of time, it could make it much harder to gather the type of evidence that USCIS likes to see in cases. Things like photos of you together, shared experiences, shared social and family bonding outing events, and proof that you have spent real time together as a couple. So if you met online, make sure you hold on to your travel records, screenshots of your conversations that can go back a long time, and any evidence to show that you made visits with each other in person. The more that you can show of their history and progression of your relationship, the better it will be for your case. Now, this one is a little bit uncomfortable to talk about, but we do need to discuss it because it can play a huge role in your case. USCIS will flag cases from certain countries more than others. Countries like China, India, Philippines, Nigeria, and Jamaica tend to get flagged more often than others. I rarely see the same level of attention being given to my clients from Ireland or from the United Kingdom or Australia. This often falls along economic lines. The lower the economic status of a country, the more suspicion that USCIS will place upon people who apply for marriage benefits from that place. I know that this is frustrating to hear and scary, and yes, it is 100% unfair. And I have found that this scrutiny is undue for the majority of cases. But unfortunately, this is really how the system may end up working. If you and your spouse cannot communicate in the same language, this is going to be a strong red flag for USCIS. Understandably, the officer is going to have a hard time believing that you guys can communicate together where you do not have the same shared common language. And they will find it hard to believe that you have been able to build a deep, meaningful relationship without being able to understand each other. Now, love is love, and somehow millions of people have been able to figure out how to communicate and have a relationship even despite a language barrier. But USCIS honestly tend to be pretty rigid, prejudicial, critical, and skeptical of even small things. And a language barrier is going to get in the way of what they consider to be a legitimate marriage. So when they see two people from two very different cultural backgrounds or from two very different religious backgrounds, this can raise questions too. USCIS internal guidelines flag age differences of 10 years or more as something that officers should pay extra attention to. And they tend to look even harder at cases where the woman is significantly older than a man. Now, I have gotten many of these cases approved over my past 16 years as an attorney, including many cases where the age gap was even much more than 10 years. So a large age gap does not necessarily mean that your case is going to get denied, but you should definitely expect extra questions, extra scrutiny, and extra problems as a result. You need to be prepared to explain how your relationship works, what drew you to each other, how the age difference has been handled in practicalities, and also just make sure that you know each other very, very well. Now, this is a big thing that tends to catch a lot of people off guard. How you file your taxes matters a great deal in your immigration case. If you file your taxes as head of household, that is a major problem. The IRS defines head of household as someone who is either unmarried or not living with their spouse for the last 6 months of the year. So if you walk into your USCIS office saying that you live together, yet provide a tax document that says that you or your spouse is the head of the household, this is going to raise a lot of questions because it is a major red flag. And these two things directly contradict each other. Filing separately can also raise questions because it suggests that you and your spouse are not actually financially connected the way that USCIS expects married couples to be joined. So whenever possible, please make sure to file your taxes jointly. This one is becoming a bigger deal every single year. Starting in 2025, the Department of Homeland Security began requiring social media handles on immigration forms, including the I-485, I-751, and the N-400. This covers over 3 million applicants every year, and it means that USCIS is going to be looking at your private profile. They're checking for things such as your relationship status, your photos, your location, check-ins, and whether your online posts match the information that you claim in your application. If you say that you have been in a relationship with your spouse for the past 3 years, but your public profiles show no traces of your spouse, or worse, one of you has a single relationship status, then this is going to create a problem in your case. So before you file, make sure you go through your social media, make sure it's consistent with your story and your timelines, and make sure that there is nothing that would raise a problem for you in your case. Okay, so now we are going to go into the red flags that carry even more weight and create more problems. If you have never introduced your spouse to your family or friends, never posted a single picture together, or never mentioned your marriage to your parents, then this is a red flag that USCIS will consider thoroughly. Most people can take time to bring their significant other into their family relationships, but in the real world, most people do eventually end up introducing their spouse to their families. If USCIS does not see any evidence of this, they are going to wonder why no one in your life seems to know that this person exists. Now, I understand that there may be some very real reasons why you may decide to keep your relationship quiet and not on the radar of your friends or family. Maybe you are estranged from your parents. Maybe you know that certain family members will not approve because you married outside of your culture or outside of your religion. But even in these situations, you need to take some steps to try to introduce your spouse to your family and friends, or at least to other people that you are close to in the community. You need people to be able to confirm that this relationship is real and that they know it to be real. USCIS pays very close attention to the timeline of your relationship. If you met someone, got married very quickly, and then immediately filed for a green card, USCIS is going to take one look and immediately grow suspicious. And this goes beyond more than just a quick courtship. Getting married right after your visa expires raises questions. Getting married while you are in removal proceedings raises questions. Filing for a green card within weeks of a wedding can also raise questions. Basically, if the timing of the marriage lines up a little too perfectly with an immigration need, that is where USCIS's hackles are going to be raised, and they're going to have lots of questions and scrutinize your case even further. They're going to wonder if your marriage is actually real or if it was arranged for the purposes of obtaining immigration benefits. If you and your spouse list different addresses on your application, this is one of the biggest red flags that you can have in your marriage green card case. Cohabitation is considered to be the strongest evidence that you have a real bona fide marriage, and not living together can definitely trigger what is called a Stokes interview. A Stokes interview is when USCIS will separate you and your spouse into different rooms and ask you questions independently in order to compare how you answer. As of 2025, some field offices have even started doing Stokes interview instead of a regular interview from the very start of the case. Even if your case starts out with a regular interview, if the officer becomes suspicious during the course of questioning, they can still separate you into separate rooms and question you with the Stokes. Now, I want to be clear, there are some very legitimate reasons why couples may not live together, such as having a job in a different city or going to school or being in the military, but you must be able to have a valid reason, and not just a valid reason, you must be able to explain thoroughly the need to live apart and why your marriage should still be considered to be bona fide. USCIS wants to see evidence that your marriage is real, but there is a balance that you need to hit. If you submit very little evidence, they're going to assume that you cannot prove your case. But if you submit way too much, they may feel that you are trying to overcompensate and you are trying too hard because you have something to hide. So be very careful about the timing and amount of your evidence. If all of your joint bank accounts, photographs, and affidavits from friends were created in the month or two right before you filed, USCIS may notice. Creating a bunch of evidence right before the timing of your filing is exactly what people do in fraudulent marriages. Real couples gradually build their documentation over time and over the course of their relationship. So start collecting your records early and make sure they show how your life together has developed over different time periods. Even small innocent mistakes in your application can cause big problems. If you accidentally write the wrong wedding date, list an old address, or your spouse gives a slightly different version of how the two of you met, then USCIS can treat it as a material inconsistency, which is something that happens when things in your case do not match up. And material inconsistencies, even if they are honest mistakes, can be held against you as potential signs of fraud. This is also the type of thing that can trigger a Stokes interview. So before you file your application, make sure you go through every single page and double check it. Before your interview, make sure you sit down with your spouse and go over all of the details and history of your timeline of the relationship. If you are a U.S. citizen who has previously filed for a green card for a previous spouse or for more than one spouse, USCIS may get suspicious and treat this as a red flag as well. This applies to both the petitioner and the beneficiary, and it is one of the strongest pattern of fraud indicators that USCIS will use. It can be overcome, but the burden will shift heavily to you, and USCIS will certainly scrutinize your case. You'll need to clearly explain the history, how the previous marriages ended, and why they ended, and also present even more evidence that this current marriage is in fact genuine. Criminal history has also always been a red flag in green card cases, but the stakes are much higher now than they were even a year ago. As of 2025, August, USCIS updated their policy so that a denial of a marriage green card case can now trigger a notice to appear in immigration court. Before this policy change, getting denied did not automatically mean that you'd be put into removal, but that has changed. And also, there are now reports that USCIS may even issue biometrics appointments to the U.S. citizen petitioner to investigate their criminal history for the case. So if either you or your spouse have any sort of criminal record, and I mean even old charges, dismissed cases, things that were expunged, you need to get your case reviewed by an immigration attorney and make sure you disclose events of criminal history from both sides. The risk of getting this wrong is more than just denial. It can put you directly in front of an immigration judge. My name is Moumita Rahman, and for the past 16 years, I have been practicing immigration law in the beautiful state of New York, helping clients all over the United States. If you would like my help on your case, give us a call to schedule a case evaluation at 212-248-7907. And I have helped hundreds of people get approved for green cards, even with the red flags that I have mentioned before. And speaking of your marriage green card case, the timeline for how these cases are being processed has completely changed underneath the current administration. Whether you're married to a U.S. citizen or a green card holder, whether you're inside the United States or going through consular processing abroad, the steps and the waiting periods look much different than they did even a year ago. I break it down step by step in my other video, the real timeline for marriage green cards in 2026. I'll include a link to that video here. Click to watch it next, and I'll see you there.